Your mom just passed away and you're sitting at her kitchen table, staring at a pile of unpaid final bills and trying to figure out how to keep her house from going into default. You find a faded envelope in the back of a drawer with a handwritten note saying you get everything. It's signed and dated, so you might assume you're completely protected. That assumption is a very expensive mistake. People constantly mix up wills and trusts, and using the wrong one, or using a handwritten napkin, can cost your family thousands of dollars and trap your inheritance in court for over a year. Today, we're breaking down the biggest mistakes people make with these estate planning tools, why those errors cost so much, and how the system actually expects you to handle your assets. The most dangerous mistake is assuming that having a will keeps your family out of court entirely. A will, formerly known as a last will and testament, is just a basic set of instructions that tells the court who gets your stuff when you die. The critical part is that word, court. If you only have a will, your family has to go through a specific legal process called probate. Probate is the court-supervised procedure of proving the will is valid, paying off any final creditors, and legally transferring your property to your living relatives. Imagine your dad passes away and he left a will saying you inherit his paid-off truck and his house. The will doesn't magically hand you the keys. The will is essentially a letter to the judge. Your dad's estate has to be opened in probate court, meaning a judge has to look at the will, officially confirm it's real, and sign off on transferring the title before you can legally sell the house or even register the truck in your own name. This court process is public, meaning anyone can see exactly what your dad owned and who he left it to. Depending on the backlog in your local county, this process can easily take 6 to 18 months. During that time, the house just sits there, property taxes might stack up, and your family is waiting on a judge just to move forward with their lives. The financial cost of probate is the real killer. Many states allow the executor of the estate, which is the person named in the will to handle everything, to charge a percentage of the total estate value as their fee. On top of that, the court charges filing fees, and if a lawyer gets involved to help navigate the paperwork, that's another massive chunk out of the inheritance. If your dad's house was worth $300,000, a percentage-based executor fee and legal fees could easily eat up tens of thousands of dollars before you ever see a single dime. People think a will is a shield against the legal system, but a will is actually an invitation to the legal system. The second massive mistake is thinking only incredibly wealthy people need a trust. A trust is a private legal contract that holds your property and spells out exactly how it gets managed while you're alive and exactly who gets it after you pass away. When you set up a trust, you transfer the ownership of your assets, like your house or your bank accounts, out of your own name and directly into the name of the trust. Think of it like a locked metal box. You build the box, you put your property inside it, and you write a private rulebook for exactly who gets to open the box and take things out. While you're alive, you can be the trustee. The trustee is the person legally allowed to manage the box. If you suffer a severe medical emergency and can't make decisions for a few months, your trust names a backup trustee who can step in immediately to pay the mortgage or manage the property without asking a judge for permission. The biggest difference happens after death. When you pass away with a fully funded trust, your family completely skips the probate court process. Because you don't own the house in your individual name anymore, the trust owns it. The trust doesn't die when you do. The rulebook just immediately activates, and your backup trustee distributes the property exactly how you wrote it down. There are no court filing fees, no public records, and no judge overseeing the transfer. A trust costs a bit more money to set up properly on the front end than a basic will does, but it often saves your family a fortune in court costs and massive delays later. A third brutal mistake people make is relying on a handwritten will they printed off the internet or scribbled on a notepad. In some states, a document written entirely in your own handwriting, signed and dated, is recognized as a valid document. This is called a holographic will, but relying on this is like navigating a minefield blindfolded. These handwritten notes are famous for missing critical legal language. If the document doesn't explicitly waive a surety bond, your family might be forced to buy a special type of insurance policy from a corporate bonding company just for the privilege of managing your estate in court. That policy can cost thousands of dollars, draining the estate before anything is even distributed. These informal notes also rarely account for alternate beneficiaries. A beneficiary is simply the person named to receive your money or property. If your will says everything goes to your brother, but your brother tragically passes away a month before you do, and you never updated the document, the court has absolutely no instructions on what to do next. A valid estate plan always includes backup options so the money doesn't accidentally end up going to a distant relative you haven't spoken to in 20 years. The fourth mistake involves the most valuable asset most blue-collar families own, the family house. A will does not override a legal contract. If you own a house with your spouse, how your names are written on the property deed matters entirely. A deed is the official physical document that proves who legally owns a piece of real estate. If the house deed says you and your brother own the property as tenants in common, and you pass away with a will that says your half goes to your daughter, the will controls the property, your daughter gets your half. But your will has to go through probate court to make that happen, which costs time and money. However, if that same deed says you and your brother own the property with right of survivorship, that specific legal phrasing overrides whatever your will says entirely. Right of survivorship means that the moment one person dies, the surviving owner automatically inherits the entire property by the sheer operation of the law. The will doesn't matter for that specific house. The property transfers instantly, outside of court. People constantly write contradictory things in their wills without actually checking how their physical property deeds are titled, causing massive legal battles and confusion among siblings after a parent passes away. A related mistake is ignoring beneficiary designations entirely on your financial accounts. If you have a life insurance policy or a retirement account through your union, that paperwork includes a form where you write down who gets the money if you die. This is a beneficiary designation. When you pass away, the life insurance company doesn't care what your will says. They only care what is on that specific form. If your will says your current spouse gets everything, but you forgot to update your life insurance beneficiary form after a divorce, your ex-spouse gets the entire life insurance payout. The insurance company is legally bound to follow the specific contract of the policy, completely ignoring the will. If you want to avoid these massive errors, you need to understand how these tools actually work together. Think of a will as a fallback plan and a trust as the primary shield. Many families benefit from a setup that includes a basic will alongside a comprehensive trust. This is often called a pour-over will. A pour-over will acts as an ultimate safety net. It simply says that if you forgot to transfer an asset into your trust before you died, the will catches that forgotten asset and pours it into the trust, where it can then be managed privately according to your rulebook. The most important step you can take before paying a lawyer to type up any documents is taking a complete inventory of what you actually own. Grab a notebook and list out the bank accounts, the vehicles, the property deeds, the insurance policies, and any company pensions. Look at exactly whose name is on the title or the account card. You can't make an informed decision about whether you need a simple will or a full trust until you know exactly what you're trying to protect and how it's currently titled. Every single state has different rules regarding property, probate, and trusts. What works perfectly in Texas might operate completely differently in Florida or Ohio. Some states have streamlined probate processes that are relatively cheap and fast, making a full trust unnecessary for smaller estates. Other states have incredibly expensive and lengthy probate courts, making a trust an absolute necessity even for working-class families who just want to protect a modest home and a single savings account. Because the local laws vary drastically and constantly change, you have to look up the specific procedures in your specific county. This is exactly why generic internet forms are so dangerous. A document printed from a random website might be perfectly legal in one state, but completely worthless in another. You don't want your family finding that out the hard way while they are grieving. You need to consult a licensed local attorney who understands the specific rulebook in your area to get this right. Don't try to cut corners to save $200 today when it might cost your kids $20,000 tomorrow. Taking care of this isn't about building massive generational wealth. It's about protecting what you worked incredibly hard for so that the government doesn't tie it up in red tape for years. It's about making sure your family can focus on healing instead of fighting a judge over a deed or trying to interpret a handwritten napkin. What is the one specific asset you worry about your family having to deal with the most if you were suddenly gone tomorrow? Drop your answer in the comments below so we can see exactly what's keeping you up at night right now. If this breakdown helped make sense of some confusing legal terms, pass it along to a coworker or a family member who's been putting off their own paperwork. Make sure you subscribe to the channel so you always have a reliable guide when life forces you to deal with the fine print.